that's going to come to our industry, and I don't know if it's going to be a good change or a bad change or both, is AI, where there's those that believe that AI will replace a lot of lawyers, or at least a lot of the young lawyers and the work they do, that it can do it just as well, if not better. Right now, that's wrong. AI can be useful, but it's a very dangerous tool. We've seen, and this is prevalent at the courts now, somebody will ask AI to do legal research to say, find me cases that support this proposition. And AI often wants to please you.
Hi, welcome to the Current by Oceans. I'm your host, Kaylor, and today I'm joined by Glenn Kantor. He's the founding partner at Kantor Kantor. Welcome to the show, Glenn.
Thank you.
So, Glenn, before we get started, can you please tell us about your career, who you are, what you've been building, how long you've been doing this for?
Sure. Well, out of law school, I knew I wanted to be a litigator, applied for a job, number of jobs, and was offered a job by a law firm who happened to be a litigation firm, and their primary clients were insurance companies, mostly health, life, and disability insurance companies. And I was hired to help defend them when they were sued. And I did this for about 6 years, was trained to be a lawyer. I think I got good training. But one day my boss called me in, a senior partner, and said, we really like your work. You're a good lawyer, but you seem to hate what you do, in that you don't like our clients. And well, we're not telling you to leave, but you might be happier if you went out and opened a firm to represent people against our clients. And he was a very smart man, because I didn't like what I was doing, because I found myself representing insurance companies who had taken positions that I didn't agree with. I thought they were wrong. Thought they were looking for ways not to pay claims when they should have. I mean, obviously there were cases of fraud that I have had no problem defending them on, but there were so many cases that I just thought, you're just wrong. The clients weren't happy when I would tell them that. So it created a little friction. So along with a colleague, in 1992, we opened a law firm with the sole purpose of representing individuals against insurance companies. And we did this for 12 years very successfully, but we kind of drifted off in different directions. He wanted to do more class action work, and I wanted to represent just people. And my wife, who was also an attorney working for a big firm, decided she'd like to do what I was doing. So we joined together in May 2004 and created Kantor Kantor. And I've been doing this now for 40 years in some form, and she's been doing it for 22. So that's kind of who we are. We built a firm. We have about 15 lawyers. We are now nationally known for what we do, which is representing people against their insurance companies.
So that's a pretty unique and very interesting story, Glenn. I love how you almost switch sides just out of integrity. I think that takes a lot of courage, but I'm curious, what was the most challenging thing about making that switch? Was there something surprising to you there? Was you run into any hurdles when you did that?
Well, when I first did it, I went from having a steady salary to having to build a practice. And when you do the kind of work I do, which is you get paid basically on a contingency, you get paid when you win or settle a case. For the first year, I basically had very, very little income. Luckily, at the time, my wife was a partner in a significant firm, so we were able to live on her salary pretty easily. And there are many other differences. When I was working for the large firm, I was not dealing with people so much as corporations. Now I went to work with people who were having difficulties. Either they had a loved one die, they were disabled and couldn't work, had health challenges and couldn't get their bills paid. So I was really now working in a completely different environment and working with people who were having problems. And the other thing was, now I was running a business where before I was just somebody's employee. At the start, that was not so challenging because there were only two of us and a secretary. That changed over the course of the years, where I now have about 50 employees. Running a business is kind of separate from the practice of law, although at this point of my career, I've done a good job of separating myself from the practice of law, and others basically run the business. I don't have to do that anymore.
So just to get the story straight, because if I'm hearing this correctly, you went from being paid very comfortably at an organization whose primary clients were corporations that probably already had, healthy cash flow and didn't have any trouble going through everything that had to do with hiring you guys, clients that were probably very easy to support. And then you just changed all of that out of integrity so you could support the people, actually defend them against the corporations when you felt things were being unfair, and on top of all of that, took it upon yourself to build a business, and you were doing all of that at the same time. Is that correct?
Pretty much so. If you remember, our clients were insurance companies, and insurance companies, one of the largest entities as an industry in the country. There was no issue about them paying the law firm I worked for their bills. So that was never an issue. I had no involvement in that. I just got a paycheck. And as you say, I then switched to representing people, and I only got paid if I won. There was an art to also accepting cases you thought you had a pretty good chance of winning. And you also had to do things like determine if the client was credible and if their stories panned out. Sometimes people would tell us things that just weren't true, and we had to do a fair amount of, as I said, filtering the clients to make sure we were comfortable representing them. Um, 99% of the clients that hired me, I felt comfortable with. There were times over the years when I decided a client was basically trying to defraud an insurance company. And when that happened, we quickly, I hate to say fired the client, but ceased representation because our integrity was always extremely important to us. The insurance companies that we sued, and we sued the same ones over and over again, knew that if we brought a lawsuit against them, there was some merit to it, that we were never just bringing lawsuits in the hope to get a quick settlement. That was not
Mhm.
our way of practicing.
Got it. Great. So there's so much to unpack there. I mean, I love to ask you a lot of questions, especially about the contingent compensation, right? Upon winning cases. That's a big topic for me in law that I'm very interested in. But before we dive into those specifics, tell me about your day-to-day operation now. I mean, Glenn, on from Monday to Friday, what are you doing? What are you spending most of your time in? And I know that as a leader, it probably is a mix of things, but give it your best shot at trying to compile that into a relatively short description.
Ooh, okay. Well, I've now been practicing 40 years. And for much of my career, I was in the trenches. I was drafting briefs and reviewing files, uh, doing the basic work of a lawyer. Over time, my role has switched as I've hired lawyers and trained them. Now I have a 39-year-old son who's is a lawyer, is now our managing partner. He stepped into our role, and he's doing a lot of that work. I don't know if people are Godfather fans, the movie, but towards the end of the movie, the Godfather retired, and he was just advising his son. And that's kind of my role now, as much as I can do that, which is to strategize on cases, negotiate settlements, which has always been a forte of mine, provide people my knowledge about the law. Over 40 years, I've gathered a lot of arcane knowledge about no, I shouldn't say loopholes, about the obligations of insurance companies. And even if the facts may not jump out at somebody about how we can win a case, I may have some knowledge that I can impart that helps us win. So, as I said, we have 15 lawyers, and I'm constantly talking to all of them about their cases and what they might do to improve their chances of winning, strategy ideas and such things. And as I said, most cases for a law firm like mine will settle, probably well over 90%, and done thousands of what we call mediations, where we're trying to settle the cases. And it's kind of like a game of poker, where you know what cards you have, you know what cards they have. There's some on the table, and you try and figure out how to get the best settlement for your client. And as I said, that's a forte of mine, and I've been trying to train the lawyers younger than me how to play legal poker so that they can get the best settlements for our clients.
Mhm.
My day starts early. I'm looking at email. When I started my career, there was no email. Now I get probably between 100 and 200 emails a day, and that's not counting the spam emails, which are probably over 1,000. I'm responding to emails, texts, After COVID, my legal team is spread out across the country. So we mostly communicate via Teams with, video chat, and I'm doing that all day long. And I'm also talking to potential new clients about why they should hire Kantor Kantor versus one of our colleagues. And oftentimes, and I'm going to be honest, I will say to them, you know what? You've talked about hiring this person. If it were my sister, I'd be very comfortable with my sister hiring this particular lawyer because I have a lot of colleagues that I have a lot of trust and faith, and they're really good. We're a relatively small niche of lawyers, and we are very congenial. While we all compete for cases, we all share our knowledge and work together. So it's not a cutthroat business from our aspect as far as competing with other lawyers. We do work together. So that's kind of my day. Every day is different.
So there's so much again to unpack there. Let's talk about the emails. What are you responding to? Are they updates on cases? Are they prospective new customers? Are they questions from colleagues? What is in that mix?
You've covered a good part of the gamut. There's potential new clients who we have a system to talk to them, but somehow they find my personal email and they come to me. And I look at it, and sometimes I will pick up the phone and call them. Most of the time, I send them off to our intake team to contact them and gather the documents we need to see if we can take the case. I'm getting emails from opposing counsel about we need to do this, we need to do that, or would you like to try and arrange a settlement conference? Also, we get dozens and dozens of emails from the court about cases and requirements and date settings and things like that. Occasionally, we have a lot of cases, we'll get a ruling that when you start to open the computer, it's like, okay, did I win or did I lose? Which is a very exciting moment. Usually it works out better than not, but we don't win them all. And, those are my emails, just a wide variety of all kinds of things. And I do try and respond to them as quickly as I can. I know it's very frustrating for clients when they want to talk to their lawyer and the lawyer doesn't respond. So we make it a habit of responding as quickly as we possibly can to our clients. Sometimes it's just, you know what, can't talk to you right now. We'll get back to you within 24 hours. But we want them to know that, we're not ignoring them. We're on top of it.
Right. So, Glenn, anybody who's familiar with this show knows that we host many people who are in healthcare. And what you're doing is right up that alley as well. So I wanted to really ask you about from the standpoint of law services that are adjacent to healthcare. What is there to know? Was there something that you had to get trained in? Is there specific knowledge and things that are done a little bit differently than you would elsewhere in other, let's say, verticals of law?
Uh, Absolutely. I mean, it's almost like asking a doctor, after you finish medical school, could you perform all kinds of medicine? Could you be a gynecologist and a orthopedic surgeon and a rheumatologist at the same time? It's like, no, you get trained in a special area. The days of generalists are long gone. And as I said, we have a pretty narrow niche, which is insurance law. And every state has their own laws on how to deal with health insurance. Life insurance is pretty ubiquitous across the country. The laws are pretty much the same as with disability insurance. And also a new niche we have is long-term care insurance, which covers the needs of the elderly as they start to need specialized care, and it's kind of a new area of law. But it took me years to learn this. I learned it first from the defense side and then started to learn more from the plaintiff side. And there's just a lot to learn, and it's ever changing because there's the statutory law, the laws passed by either Congress or the state legislatures, but then the judges have to interpret that law. And they are constantly coming up with new interpretations, new set of facts, and you've got to stay up with that. So we are constantly learning. Also, and this may be a bit deep for your listeners, I don't know. For the most part, if you get your health insurance or life insurance or disability through your employer, and your employer is not a government, then you're governed by a federal law whose acronym is ERISA, which stands for the Employee Retirement Income Security Act of 1974. And it's a very complicated law that was intended to favor insureds, and it was intended to make sure pensions were solid. But over the years, the insurance companies and the courts managed to turn it on its head to protect them. And it's very, very much used by the insurance companies as a sword and a shield against insureds. If you get your coverage and it's not through your employer, then you're governed by the state law where you live. I luckily practice in California that provides some strong remedies against insurance companies that don't act reasonably, that take steps to improperly avoid paying claims. So we have to learn two entirely different areas of law. We actually have lawyers who focus more on one end than the other because it is so complicated. Really become, from our perspective, we train lawyers to become an expert in their particular area.
That is fascinating. And by the way, I don't think you don't have to fear going deep. I mean, this is deep current after all. And this is exactly the stuff that we're here for. So that is incredible. Now, and that it does lead me into a question. As I've said, I mean, I've spoken to many healthcare leaders, and one thing that comes up very often, which is a recurring topic, is claim denials. They seem to be rising year on year. I mean, far as I heard, I think last year was around 12%. I've heard guests say maybe they estimate up to 15% in some states. So I'm curious. I mean, does that sound about right? That claim denials are rising, and why is that? Why do you think that is the case? Is it a law thing? Is it policy thing? Is it what is it?
Oh, we could spend hours discussing that, but there's a lot of variables. Insurance companies are there to make money. So the idea for them is take it as much premium, invest that premium, and pay out, well, I hate to say as little as possible, but to pay out only what they feel they have to. I'm cynical, and I've given a lot of talks over the years, dozens and dozens, and I try to get into this at the start that the people who come through my door never come in and say, you know what? I made a claim to the insurance company and they paid it. Will you sue them? All I'm getting are people whose claims were denied. So my view is a bit skewed. Just, there's a high percentage of claims that are denied. Why is that? Now, as I said, the insurance companies are there to make money. And also, as medicine advances, there are all kinds of new treatments which can be very expensive. And the insurance companies just don't want to pay for it. If you want examples, my wife, who's Lisa Kantor, became one of the country's, if not the country's leading advocate for mostly women and girls with eating disorders, bulimia, anorexia. The treatment for that is usually inpatient care in a facility, and it can run $1,000, $2,000 a day and can take 60 to 90 days. And the insurance companies, it's just an outrageous amount. And their response is typically, no, it isn't necessary. You don't need that treatment. Well, of course they need it. These are life-saving treatments, but they just don't want to pay it. And if the insured is governed by ERISA, there's really no sword over the insurance company's head. They know that the worst thing that happens to them is a judge says, pay the claim, and there's no damage that goes along with it. And they know that many people will just walk away and give up. In the cases like the one I talk about where the numbers are really huge, I think there's less walking away. But anybody who's gone for maybe it's a routine test, and maybe the insured is responsible for $500 and the insurance company pays $10. The insured, my potential client, is between a rock and a hard place. Like, can't hire a lawyer over 400 hours. It just is not cost effective. They can write to the insurance company and ask to be paid, but they're going to get ignored. So it's a very hard thing to fight when the bills are small. And for one person, okay, that 400 hours might be significant, but if you multiply it by a million denials like that, well, now you've got a $400 million pile of money that the insurance companies are keeping. So I think a lot of the denials are because they know they can get away with it. And once again, it's cynical, but I believe it happens. Over the years, we've seen some horrific conduct from insurance companies doing things that you wouldn't believe. I've seen insurance companies forge signatures of insureds to reduce their coverage on a mass basis. I was involved in litigation over an earthquake 30 years ago where an insurance company was forging their insured's names on policy documents, reducing their coverage from unlimited coverage to a limited amount. And they got caught. and they paid millions and millions of dollars in damages for doing that. And it always astounds me when this happens because the people who work for large insurance companies, it's not their money. They're just working for a huge entity, whether it be, and I'm not picking on these companies, it's just using familiar names, whether it be State Farm or Allstate or Prudential or United Health or Hartford. When people do bad things, I mean, clearly bad things, you wonder, why are they doing this? The money is not coming out of their pocket. I've always wondered, but I guess people just develop a loyalty to their employer and feel that what they're doing is best serves their employer, makes them look good to their superiors.
Well, that is appalling. But I believe you because I've experienced some of that firsthand, like the nightmares of trying to claim amounts that aren't quite as high, where it would make sense to really make a fuss out of it. But at the same time, it is money that is there. It's being lost by the people who are hiring these companies in the first place. So there's so much that I'd like to ask you about that. But I mean, let me start with this. Do you feel like a lot of the percentages of the claims that get denied is from the people's lack of understanding of the process because maybe it's built in a way that makes it difficult for them? Or is it that genuinely the companies are, maybe the person did everything correctly and then the company still denies it? That's why they come to you. I like to kind of understand if there's a mix there or if it's totally random.
I don't think I could put a percentage on it, but both of those things happen. Um, the person making an insurance claim is not an expert. They're a layperson for the most part. They think they're going to make a claim. The insurance company, is going to help them and it's going to all get taken care of. Well, that doesn't happen. Sometimes it does, but oftentimes it doesn't. There are insurance companies that put up walls to make it harder to make claims, and people don't know what to do. We give talks on what you have to do. An example, never telephone an insurance company and tell them something that you want them to know because you have no proof it ever happened. Write them, email them, and keep evidence that this communication took place. So the insurance company can never say that didn't happen. If you mail them important documents, send them by certified mail so you have evidence that not only did you send it, but they got it. I talked about ERISA. When the law was passed, it contained a requirement that if a claim is denied, the insurance company had an obligation to, if the insured requested it, to give it a second look. It's either called an appeal or request for reconsideration. So if you put in a claim for a surgery and the insurance company said, no, this wasn't medically necessary, or your doctor was out of network, or doctor charged too much and they refused to pay, you had the right to appeal and say, look at this again. Turned that around and said, you have to appeal. Because if you don't appeal, you can't file a lawsuit. And I've seen dozens and dozens of cases over the years where people didn't understand and didn't properly appeal. And then the courts would say, we're sorry, you have no right to file a lawsuit. And that, this was a law passed to protect people. And again, it's being used to protect insurance companies. And that's just wrong. The insurance companies would say, you may appeal. They didn't tell the people, if you don't, you can't sue us. They would say you have so much time to appeal without telling them what the date was. And it would get confusing and people would let the time run. So insurance companies are considered either fiduciaries or quasi-fiduciaries, which means they have a special relationship with their insureds where they're supposed to be helping them, but they typically do not follow those rules. They look at it
Mhm.
as an adversarial relationship where the insurance company has the money, the insured wants their money, and it's a fight. But once again, I'm seeing the fights. I'm not seeing as much where the claims get made and they get paid. I mean, I have 3 children, 3 grandchildren, been making insurance claims for my entire adult life. And for the most part, they've been taken care of. I do get the cases from my own family where we end up with a $50 dispute. And I'm not going to do anything about it either. I've never personally sued an insurance company for myself. It's just not worth the effort.
But let's pivot very quickly from the industry of insurance and back into your firm and the work that you do at Kantor and Kantor. There's one thing that strikes me about the professional services firms, particularly law is a big one here. And it is how much revenue gets actually built, maybe even projected, and then how much you actually goes back into your cash flow. I mean, I've talked to people, they tell me maybe they're building 65 to 70% the actual hours that they work. I mean, and I don't know if that's your case or not, you'll tell me. But the realization rates in the industry, from the last that I read, they average 78 to 82%. So firms at best are collecting maybe 82 cents on the dollar. And I'm curious, is that a problem that you've seen at the firm? Is that something that you've dealt with before?
Because we're a contingent firm, it's a different model. If I'm going to use, small made up numbers, if we settle a case for a client for $100, the money is paid to my client trust account. We have a retainer agreement with the client that specifies what percentage we get. It can vary depending upon what stage of the case it settles. But let's suppose our retainer says we're supposed to get 25%. So of that $100, 75 is sent to the client, and we then transfer $25 into our general account. So uh, we don't keep track of time um, on all cases. Some we do, some we don't. But because the nature of our practice is contingent, uh, if we're successful, we can get paid a lot of money per hour for the work done. But at the same time, if it turns out that we don't win, we can put in a lot of work and get nothing per hour. I've had cases where I've written a letter and gotten a check back from an insurance company for $1 million. And the client sometimes is very grateful. Sometimes it's like, wait a minute, you're charging me $250,000 because you wrote a letter? And I can see how they deem it unfair, that they, in retrospect, wish they had just hired me to write the letter. But my response is, you're not really paying $250,000 for the 2 hours it took me to write the letter. You're paying for the 40 years it took for me to learn what to put in that letter to get them to pay. Because they know if they don't pay, I'm going to file a lawsuit and seek damages. So, sometimes we get paid a lot per hour. Sometimes we work for free.
That makes it almost, I mean, not almost, it makes it more complicated. So how do you project in a way that is predictable and that, you know, where you can track efficiency across your organization to understand how many people you need to have, which cases to pursue, what goes into that decision making?
Well, we start with talking to the client and assessing how much money is at issue. And it's kind of an XY analysis. The more money that's at issue, uh, that allows us to take cases, maybe the facts are not quite as strong because we think it has settlement value, because we can make an argument that we have a chance of winning and the case will likely settle. Sometimes the money is uh, there's not a lot of money at issue, but the facts are incredibly strong. And I can't tell you how many phone calls over the years of people who say, I talked to 3 law firms and they said, oh, my facts are really good, but it's just not worth the money. And my firm has a culture of saying, you know what, we don't care. If the facts are that good and you're being denied a benefit you need, we would like to find a way to help you for a variety of reasons. One, we've had a firm motto for as long as I've had the firm of, we can do well by doing good for people, so that we do want to help people. We often do things pro bono when the money is so small, but we want to help somebody. And at the same time, a lot of our business is from word of mouth. If we help somebody who really needs help, even though it wasn't particularly profitable, and they tell their friends, they tell their relatives, they tell their coworkers, well, we get business that way. But we do an initial intake to see just how strong the facts are. And after all these years, it's a gut feeling. You get a sense of what a judge or a jury is going to think about a denial. Give you an example, somebody with a bad back who has a desk job and they claim they can't sit at the desk job because the back hurts too much. But the x-rays and the MRIs don't show significant problems, and the people are not taking strong medication for their back, and they're not doing therapy. And we have got to present this to a judge, and I'm going to think, well, the judge, who's probably up there in years, is going to think, well, I have a bad back too, and I sit at this desk all day reviewing cases. I don't think this person is unable to work. We may not take that case because the facts aren't that strong. On the other hand, I'll give you an example of an individual who has multiple sclerosis and it's affecting them cognitively. Or maybe they had a functioning IQ of 125, but now it's close to 100. And they maybe had a high-end job. Maybe they were an accountant or an engineer. And the insurance company will say, well, yeah, we understand you're claiming cognitive, but there's no reason you can't sit at a desk and work because your MS doesn't prevent you from sitting at a desk. It's like, now, wait a minute. Their occupational duties require a high level of cognitive, excuse me, a high level of cognitive functioning. And you've been told that they've lost that ability, but you say you're going to deny their claim because they can sit at a desk and do what? So that's the case. We're going to say that's just really wrong. And we're going to take that case, whether there's a lot of money or not a lot of money. I've seen cases with surgeons with very minor cases of hand tremor, central tremor. And the insurance company says, well, it doesn't appear to be that bad. We've seen you driving. You took surveillance. You're driving. So why can't you do your job? Well, think about the job duties of a surgeon. He's got a scalpel and he's cutting on some part of your body. Does anybody want to have a surgeon whose hand is trembling while he's cutting into you? Of course not. But the insurance companies sometimes will blind themselves to the facts in order to justify the denial of claim. Those are the things we're looking at. Kind of like it's just a gut feeling, reviewing the medical records and the person's occupation and deciding, is that a case that we think the insurance company should have paid? But just over the last 4 or 5 years, we've had a lot of cases come out of COVID where it seems like everybody in the country got COVID. And most of them, it was like a flu. I mean, of course, large number of people died, which is tragic. But what we've seen, most people got it. It's like the flu. They got it and they got over it. Vast majority. But some did not get over it. It's called long haul COVID, and it's permanently affected their lungs or their cognitive functioning, and they can't do their jobs. Sometimes, if it's somebody's lungs and they're a laborer, they work at a construction site, they're like, I just can't function. Or it's also affecting people cognitively, and they can't do the job. And the insurance company seems to always have the same answer. There's no objective evidence of your inability to work because there's no real objective evidence of long COVID. Or two, and this one gets me, the average person isn't disabled by long COVID. Okay, so what? If there were 300 million cases of COVID, and I'm just picking a number out there, and 1% have long COVID. That's 3 million people. So I don't think the person who has the long COVID wants to hear about the other 99% that don't. The person's just concerned about themselves. And the insurance company is supposed to be looking at the person in front of them, not the average person. I use MS as an example. Half the people with MS have cognitive problems, half don't. And the insurance companies will always say, just because you have MS does not mean you're disabled. True. But at the same time, having it is an indication that if you have these symptoms, we know the source and you probably are disabled. So we look at that kind of case and say, we're going to take that and we're going to win. So there's no precise formula. Personally, I like the tilt of windmills. I will take a case because I think there's an avenue that others in my law firm might say, I don't see it. I think this is going to be too tough a battle, and we need to focus on, to fight the fights we think we can win.
Mhm.
So we have disagreements internally, and we work them out amicably. Sometimes, people go with me, and sometimes they decide how we shouldn't take it, and I go along with them. Cooperative effort.
So tell me this, Glenn, how many clients are you dealing with on any given day on average? I imagine this fluctuates quite a bit, but is there a sort of average, maybe ballpark number that you can pin to it?
Well, at any one time, the firm has about 200 active cases with, as I said, 15 lawyers. If your question is, how many do I deal with in the average day? I might actually talk to one or two clients in the average day, but I'm talking to 10 lawyers about maybe their clients. So I'm talking about 10 to 15 different clients in the average day out of the 200 cases because, law sometimes moves at a glacial speed. You file a lawsuit and nothing happens for several months. The insurance company gets served, they get time to respond, they typically ask for a little more time. Then the judge has to set a conference. So after we file a case, it takes a while to get going. So, and then even after it's going, there'll be gaps. So I'm dealing with the cases where something is happening and we have to make decisions. So I would say I probably am working on 10 to 15 different cases a day.
One thing I've heard from other people in law, again, is that a good portion of the, precisely because of what you just described, right? The processes are long, they're glacial. And I've heard that they spend a good portion of their time, or the team spends a good portion of their time answering questions and following up, or clients following back up with them constantly because obviously, again, they want to know what's happened. Is that something that you struggle with, that you feel like a lot of time goes into the follow up?
I don't think we struggle with it. Maybe my clients would give a different answer, but in the age of email and all the ways the courts communicate, things have changed rapidly over the last 10 years, and COVID had a big aspect or a big impact in that the courts would typically bring in the parties on a lawsuit and spend 15 minutes talking to them. And they would be talking to 20 to 30 different sets of lawyers on a given Monday morning. And now we prepare a report, we send it to the court, and the court will either have a 5-minute Zoom conference with us or just send out an order setting dates. Things have changed in that regard. And when we have dates, we send them to the client and tell them this is what is going to be happening. And so we keep them advised. And, for example, in the federal court in Los Angeles, you are required to conduct either a mediation or a settlement conference, which are really pretty much the same thing, within a relatively short time after the lawsuit is filed. The courts want the parties to sit down and try and settle. Early on, we will talk to the defense lawyers, we'll agree upon a mediator, and we'll tell our client, today is May, I don't even know what today is. Today, the 19th, July 12th, we're going to have a mediation. It's probably going to be on Zoom. We will be there by your side. The insurance company will be in a different Zoom room, and we'll have a mediator who will back and forth to discuss your case and the value. And we'll tell them this 2 months in advance, several weeks in advance. We will give them a draft of a mediation brief for them to read because while we know their case pretty well from the records, there may be things they know that they haven't told us. And we'll talk to them a few weeks in advance, and then the day before the mediation, we'll talk to them again. And then the day of the mediation, we spend it with them. If the case settles, great. If it doesn't, we'll then tell them the next step. So we think we put a high premium on keeping the clients advised on what's going on. And of course, different people have different levels of need. I can tell you that if we settle a case, people are typically in need of the money, and we'll tell the client you can expect to have the money in your bank account within 30 days. Typically, it's much sooner, but we give them kind of an outside window. And some clients will be emailing us daily. Is the money there? Did you get the money today? And, we say, no, it hasn't come in yet. We still have a few weeks. Others we won't hear from. We get the money, we let them know it's there, and they're like, thank you. And they never contact us between the time we settle the case and when we send them the money because they understand it's going to take a few weeks. So we deal with different individuals in different ways. A lot of people are very, very anxious because they've had to file a lawsuit because they've been denied money they need. And we try to understand that. We also deal with a fair amount of people who have mental illness. And the insurance companies are cynical. Policies, disability policies, will limit how long they'll pay benefits for mental illness because they're hard to prove. And I'll have young lawyers complain to me about dealing with the clients with the mental illness. They're so hard to deal with. They're constantly trying to talk to me. And I just remind them about who it is you're dealing with. Got to be empathetic and sympathetic. Hand holding is part of our job sometimes. It can be difficult because sometimes the people, either with mental illnesses or not, can be very aggressive, blaming us because it's taking so long. We don't have control over the court system. Things take a while. As long as the client isn't abusive, because I won't let clients abuse the lawyers that work for us or with us, we try and be patient. That's a big part of our day is communicating with clients. As I said, we put a high premium on keeping them advised so they're not sitting there wondering what's going on in my lawsuit.
Well, yeah, I mean,
Yeah, I mean,
I
I
figured
figured
that was a big part of what you're dealing with on a day to day. I mean, client expectations are kind of not just in this industry, but every industry, right? But Glenn, seeing that we have a little time left, I don't want to let you go before asking a couple of questions more on the forward looking perspective of things. One that I always like to ask, and it always yields great answers, is if you're truly honest with yourself and the firm and your role right now at the organization, is there one thing you like to fix? Maybe it's a problem that is not an internal problem, but it's something that you feel you have a little bit of control over. Maybe it's something from your bucket list that you've been kind of putting off because of time or hands or whatever the case. Does anything come to mind?
absolutely, but it's a battle that right now there's no way to win. I told you about the law ERISA that impacts, I don't know, 100 million people. It needs fixing by Congress. And right now, Congress can't agree on what to order for lunch. So chances of getting a congressman to recognize the problem and get bipartisan support to fix it seems next to impossible. I shouldn't say we, but my colleagues and I have been successful in California in getting the legislature to pay attention and fix things on a more local level. But changing the law in Congress just seems next to impossible. It's very frustrating as a citizen. If you watch the news, they can't agree on anything.
Yeah. I definitely see that being a big one. And Glenn, where do you see the biggest opportunity for firms your size or operators your size to compete with the larger corporations and like make a name for themselves, make a niche for themselves in the industry as a whole?
Well, in my industry, my niche, we're not competing against large corporations. We're one of the largest firms in the country that do what we do, and we have 15 lawyers. Now, there are much larger firms that do class actions, which we do occasionally, but mostly we're representing individuals. And there are not a lot of really large firms that do this. I'll tell you the biggest that's going to come to our industry, and I don't know if it's going to be a good change or a bad change or both, is AI, where there's those that believe that AI will replace a lot of lawyers, or at least a lot of the young lawyers and the work they do, that it can do it just as well, if not better. Right now, that's wrong. AI can be useful, but it's a very dangerous tool. We've seen, and this is prevalent in the courts now, somebody will ask AI to do legal research to say, find me cases that support this proposition. And AI often wants to please you. So it will give you a memo that has cases supporting the position you asked it to support. Unfortunately, it turns out it's made the cases up. They're completely fictional. And I'm sure the AI developers are working to stop that, but it's there. We've seen cases where judges have sanctioned lawyers multiple thousands of dollars for submitting briefs they were created by AI. And the lawyers didn't check to make sure that the law they're citing to is accurate. But it is an effective tool for like reviewing medical records, but it doesn't yet have a trained lawyer's eye. But it's going to get there, and we just don't know. We are trying to use it, but we're using it very carefully.
Mhm.
And the insurance companies are using it. They're using it to summarize medical records. And I don't know if they're being as careful as we are. We're seeing entire change in the tenor, and I guess I should say the quality of the writing in letters from insurance companies denying claims. And it's like, for the most part, the people who were writing these letters during my career were not college trained. They're mostly high school graduates, and the letters were not written as though they were written by someone with a college degree. Now they're written by AI, and they look like they're written by a lawyer. So we know they're using it, and
Absolutely.
it's more impressive. But the depth and the accuracy are not always there.
Glenn, those were excellent insights. Genuinely enjoyed the conversation. I love how unique this was, particularly because of that mix that you brought from both the law perspective, but at the same time, insurance and even touching up in a little bit of healthcare. This is exactly what we're here for. We want to bring this knowledge and this connection to people who listen to the show and that might be curious about how things work on your side. So Thank you so much. Glenn, where can our listeners follow what you're building, follow Cantor and Cantor, get in touch if they need to?
Well, we have a website. Can be found at cantorlaw.net. They want to talk to me or find us, they can just Google us, ask AI, and they'll get our communication, our address, email, phone number. It's pretty simple these days. But if I could give one piece of advice to your listeners, which would be don't give up. It's, the phrase, the squeaky wheel is the one that gets oiled, is accurate. If you continue pursuing your claims, if they're valid claims, and you usually have to find a lawyer, you're going to get paid. It's the people who give up that don't. So never give up is good advice.
And on that excellent note, I think we conclude our show. Thank you so much for listening to Deep Current by Oceans. If you are an operator dealing with any of the challenges that Glenn discussed here, or maybe you've resonated with anything that he mentioned and want to keep in touch, feel free to reach out to Glenn or reach out to us at oceanscode.com. We'd love to keep that conversation going. Until then, I'll hope to see you next time. Thank you.
Thank you.